case set for argument this morning is Robert Lund versus Linda Munka. It's case number 28863. Both parties are present with, or both parties are represented by counsel, I should say. So each party will have 15 minutes to present their argument. The appellant may reserve up to 15 minutes. If you're going to reserve for rebuttal, if you're going to reserve time, let me know, and I'll try to keep you appraised of the time. Also, you'll note the clock on the wall, so that can help you keep track as well. The arguments are recorded and posted on the court's YouTube channel, so we ask that you stay by the podium and keep your voice up. If there are children involved, I don't believe there are in this case, but
No.
Okay, so we won't have to worry about using the initials. The court has read the briefs, and we are ready to proceed if you are. So, counsel. Thank you.
Well, may it please the court. Your Honors, there are two major issues that I think we can group all the assignment of errors into. One is the property division and exactly how to handle that, and the other one is spousal support. Property division comes down to whether there should be interest and security in terms of life insurance, and the trial court's method of going to the statutory factors, as well as the facts the trial court used in the statutory factors. Spousal support deals with whether it should have been modified and terminated, as well as whether spousal support should have been awarded with Robert paying Linda. So I'll address the, Your Honor, I would like to reserve 3 minutes.
3 minutes? Okay, thank you.
I'll get right into the property division award. As this court knows, the trial court must consider the statutory factors in 3105.171, and this court also set forth the standard in silico. So the court has to account for statutory factors and engage in the analysis and explain why the court did what it did. First off, I want to state that Robert could have made the lump sum with the 401k, and that is the standard way of dividing this. Qualified domestic relations order, and Linda had different counsel at trial, and counsel did argue that. That's a good way to end all this. This is, we've had numerous appeals over this, and why not go back to the way just about every case is handled? The statutory factors, Your Honor, is that the 401k is a significant asset. Despite what the trial court said, the trial court said that Robert had few assets. Your Honor, I hardly think that a 401k that started at about $180-something thousand and was at about $130,000 at the times of these hearings could be defined as few. It's significant. It is readily liquid via a qualified domestic relations order. The cost of a qualified domestic relations order in terms of what it costs versus the property settlement amount is modest. Tax consequences, there's no tax consequence to Robert, and Linda, the only tax consequence she gets, as long as she rolls it over to a 401k, into an IRA, is when she makes the withdrawals. The other problem is Robert's account may not stay intact long, especially he is very soon going to be subject to mandatory withdrawals, where he will have to withdraw that down. So even if he has been somewhat conservative in his withdrawals over time, that is going to end very soon where he has to do that. So Linda's right to that asset will quickly dissipate. has significant income for his budget. This court saw from the transcript as well as the briefs, Robert's significant pension and Social Security income. The loss of the 401k is not going to cause him any hardship. And Linda's pension is significantly less than Robert's benefits. I mention all of this because the trial court, said that life insurance would be too expensive. I would submit only one type of product was submitted. There weren't any kind of lesser products that were explored. He simply looked to see, well, what if I insure, what if I insure myself for the entire amount? And the court then said that interest would be inequitable. However, Robert has his income and has his property in the 401k where it earns interest, dividends, capital gains. However, he has that invested. He gets the benefit of that. However, Linda does not while she waits for the money. The court made much of Linda never having made spousal support payments. Your Honor, let me say that that is not a statutory factor. However, I found
Well,
it
did you
interesting.
look at that in equity, though?
I'm sorry?
The judge really just looked at that in equity, didn't he?
Well,
Said, wait a second, you're wanting interest and you haven't paid anything for all these years?
but neither has Robert. And in the 2013 order, he was ordered to pay her a very similar amount. So in that order, the court removed the offset that this court was very concerned about in its previous remands, but Robert didn't do it either. So they both stand, I would argue that that is a complete wash. They both stand in equal positions in equity when it comes to that. She didn't pay, he didn't pay. And I think that's something that, on remand, that's something the trial court should address somehow, but not in terms of equity saying that I'm not going to address what we're going to do about this property settlement and let this keep going on in perpetuity. The other problem is that, we're about to get into the spousal support argument. If Ms. Munka's spousal support ends, then the whole idea of whether her money could simply be turned back around and paid to her is about to disappear. Because even though the trial court basically changed the nature of that, it's still essentially what was about to happen, especially as his 401k is dissipating and it's about to be quickly dissipated. The second issue has to do with spousal support. I'd like to start off with the fact that her investment income was used. I simply cited the non-recurring income statute as an equitable principle and not something that necessarily applies. I concede that that applies to child support and not necessarily to spousal support. However, if we look at what happened here, it did not reoccur in 2016. She meant exactly what she said at trial, which is, I took $10,700 to replace the roof, some repairs on my house, and I don't really see that happening again. And if you look at the 2016 tax returns, I think there's a couple of $1,000s that she took out for some purpose. I think this was an inequitable result, picking and choosing one particular year. And I would argue that if we're going to pick and choose a year, Robert testified that at some point in time, from the beginning of this case, back in 2004, and now, he took out $15,000 at one time. So, what's good for one side is good for the other. If we're going to start talking about non-recurring income and you're using it in a particular year, well, then he should be charged with the $15,000 that he took out at one time and say, you're liable to take that out every single year. You did it once, you're gonna do it again. Because that's exactly what they said with Ms. Munka. The trial court said, you did it once, I'm gonna assume you're gonna do this every single year. And I'm going to fashion whether I'm going to modify spousal support based on that factor. The court didn't even use all of Robert's Social Security earnings. It only used Robert's taxable earnings. The statute doesn't just say taxable earnings. The statute says all of the Social Security earnings. And I think opposing counsel in a footnote in the reply brief conceded with saying that the actual income is much greater than what the trial court said it was for Robert. Linda, in terms of hers, one of the other factors is also living expenses, her wages, living expenses. So during this case, she files the motion to terminate spousal support. And in 2015, she retires in 2016, and around that same time, then she filed a motion for Robert to pay spousal support. So if we look at this, not only did her income significantly reduce in 2016, Your Honor, it went down to $26,000 a year. Now, we can't just look at what her 2016 tax return is. That's inequitable, because it contains approximately 6 months worth of her working income before she retired. Now, we have to look at what prospectively, what is she making? And she's going to make her pension, which is about $26,000 a year. She testified that her health care premiums were over $6,000 a year. She had about $8,000 a year in out-of-pocket medical expenses. So and then she has to pay $18,000 a year in spousal support. It doesn't add up. That leaves her significantly in the red. Unfortunately, the trial court really didn't mention these facts. The trial court stopped in 2015 in terms of Ms. Munka's income, and didn't really mention what really happened in 2016, her retirement, which she credibly testified. She showed her retirement stuff. This is what I'm getting. Instead, the court ignored her living expenses. The court ignored the reduction in her income, and in terms of equity, the reason why Robert is getting spousal support in the first place was that in 2005, he voluntarily retired in his 50s. He had the opportunity to get another job, and I'm not relitigating this, but I think when we look at what happened in the first place.
I'm sorry, but you're at 2 minutes and
I'm at
10
2 minutes.
total time. So I don't know if you want to continue your argument or reserve this time.
I will reserve you.
Okay. You'll have 2 minutes and 10 minutes. I'm sorry, I was wrapped up in your argument. I lost track of the time up there.
So did I. Thank you.
All right, we'll give you 2 minutes and 10 seconds for rebuttal. Counsel, you have 15 minutes.
Thank you. Your Honors, Ken Gibson on behalf of the appellee, Robert Flood. We're here on 2 issues as indicated by the appellee. The first was a remand for the court to address why it had not ordered interest or life insurance to secure the property sale. And the judge gave that explanation. First of all, he gave an explanation that the insurance was very expensive, and he gave them an option. Say, if you'll pay half of it, the premium, you know, we can do this. She did not want to do that because it was very expensive. So the judge determined that it was just not appropriate to order life insurance to secure the $185,000 property settlement. And they did not provide any counter evidence to the quote that was submitted to the court. They had plenty of opportunity. With regard to the issue of interest, the judge specifically said, I find it to be inequitable in this circumstance, in my discretion, to award interest on the property settlement, given the fact that back in 2008, I thought spousal support was going to be awarded, and I did not make that retroactive when I did the 2013 order. Thus, she had 5 years of her highest income, and she paid no spousal support, and she paid no spousal support since then either, although, as the appellant says, that was probably offset against the property settlement amount. Although she didn't concede that, she was arguing the whole property settlement amount too. And the judge very sensibly said, look, in my original order, which is part of what's being appealed here, I took into account the fact that she had all of this years of non-payment of spousal support when she had clearly much higher income. Therefore, I feel it to be inequitable to award interest. Interest would have been fairly nominal anyway, given the interest rates that were involved at that point. But nonetheless, I don't think that you can, on this record, say that Judge Hayes abused his discretion. Not that you might not have made a different decision, but that he abused his discretion, which he clearly had, to deny interest on the property settlement. We already addressed the issue of whether or not it should be a lump sum in previous appeals, and that wasn't part of the remand as far as I understood it. It was not part of the remand as far as Judge Hayes understood it. He set forth what he understood the remand to be, that is to explain interest and to explain property settlement, security by life insurance. Nonetheless, if you get into it, you know, his 401k is in payout status and is the sole means for him living that with his pension. And the judge determined that it just wasn't appropriate. A big part of the difference in the property settlement was the fact that they valued his Social Security benefits so highly. And even by the time of the subsequent hearings, those benefits, the value had gone down significantly. I want to talk about spousal support, and I'll get to that in a minute. She filed 2 motions. The appellant kind of lumps them together, but I think it's important to keep them separate because the judge made rulings with regard to both motions. The first motion was filed on January 28, 2015. If you look at the evidence in the transcript, you'll find that in her affidavit of income and expenses, in 2015, she said she was retired, and that she was retired, and listed 0 income. In the transcript of the trial that was held before Judge Hayes, on page 76, the transcript of June 22nd, 2017, she admitted that at that time she had no intention of retiring. So essentially she misrepresented, or I would even say lied, about her retirement in her 2015 affidavit. She also had received interest income from an inheritance that she received from her father, which was not disclosed in either the 2015 or the 2016 affidavit. She did not disclose assets in her 2016 affidavit or in response to interrogatory answers, which she had inherited from both her father and her mother. And she provided little, if no detail, with regard to her own income outside of her retirement benefits. So these are all factors in determining whether or not she met her burden of proof in determining or showing that there had been a substantial change in circumstances. If you go to the 2015 motion, you'll find that between 2013 and 2015, which was the date of her motion, her income had increased, not decreased, by a significant amount. Went from around 52,000 to over 70,000. So the judge did not abuse his discretion in denying the 2015 motion to terminate or modify spousal support. Let's go to the 2016 motion. This is a motion that does not specifically ask for termination of spousal support by him or modification. Rather, it asks only for spousal support to be awarded to her from Robert. Assuming, and I'm not conceding, but assuming that the court interprets that as a motion to modify her own support level and that the court could have entertained that kind of modification as opposed to what she actually requested. You have to look again at all of the spousal support factors. Her income from 2013 to 2016 had diminished by about $6,000 on about $50-some thousand within 53 to 47, something in that nature. But that's not the only spousal support factor. If you take a look at the other spousal support factors, which I set forth in my brief, you'll find that they all argue against a modification of spousal support. Specifically, one of the spousal support factors specifically is assets and liabilities of the parties. She refused to disclose a lot of her assets, but on cross-examination at the trial, we uncovered the fact that she had a couple $100,000 worth of assets in one account that had not been disclosed, a farm that had not been disclosed, other income other than what she had indicated in her affidavit, and that altogether she had significant assets and was also a beneficiary of an estate of which she was the administrator and one of several beneficiaries, I should indicate. Robert fully disclosed all of his assets and income, and the court determined that it would be inequitable to require him to pay spousal support to her, and at the same time he determined there was not a substantial change in circumstances given all the other factors to require her to diminish her spousal support to him. I think if you look at the decision of Judge Hayes, you'll find that it makes sense. It may not have been what is normal, it may not have been what this court would have done in their own mind, but it makes sense in the circumstances of the parties. She was the one that caused a very substantial delay in the original trial, and the delay between 2006 trial and the 2013 judgment entry of divorce, and there were consequences that, that adversely affected Mr. Budd. I know this court, and this has been before the court on several prior occasions. I think Judge Hayes is now finally fully retired, so if it gets sent back, we may end up before another judge that doesn't even have any knowledge of the background or circumstances. This is a case that needs to be put to bed. The two motions that were filed, I mean, if she's got a substantial decrease in income, nothing to keep her from filing another motion. But as of the dates of these two motions, the judge determined that her circumstances had not substantially changed, and that granting those two motions would not be appropriate. If you have any questions, I'd be happy to answer them. If not, I'm going to leave the rest of my time.
Did the court consider the argument counsel made concerning the reduction, the increased cost of medical coverage, the wife's medical bills, decrease in the post-retirement income, those sorts of factors in his ruling? And if not, do you think it should
Well,
have?
the fact that it's not specifically talked about in his decision, as this court has ruled on many occasions, doesn't mean that he didn't consider all the spousal support factors.
Did he say he considered all of the spousal support factors in the entry?
I honestly don't remember.
Well, it'll speak for itself.
Sure. But I will tell you this. Her testimony, I mean, usually when you go into court, there's documentation of these things. There's paperwork, there's something. She was throwing numbers off the top of her head, and then she was asked about some of her expenses, and her answer was, I don't know, or you'll have to look that up, or that kind of thing. So, and then when I would cross-examine her on some of those, she would kind of waffle if I guess is the expression. So many of those things that she testified to with regard to those kinds of expenses were not only not documented in any way, but were not credible in the, and if you look at it, you'll see that in the transcript. Anything else, Your Honors? I can look up for a moment and see whether he specifically referenced spousal support factors. I don't remember that he did.
So is the property settlement in this case sort of left in limbo? How is it?
Now, at some point, he's going to owe her some money at the end of the day because of the court's prior rulings. Originally, the judge's idea was that it would be offset, but because these 5 years elapsed when she paid no spousal support, the math no longer works. So right now, it's offsetting. At some point, when her spousal support obligation terminates, and it does terminate, then he's going to have to start paying her. And there's no reason to believe that that she won't get that. I mean, if for nothing else, she can make a claim against him in the state or whatever. I mean, it's there. Any other questions?
I don't think there are any other questions, so thank you for your argument.
Thank you.
Counsel, you will have 2 minutes and 10 seconds left then.
Thank you.
Not quite the free you asked for, but it is what it is.
I'll manage. I'll address counsel's arguments. Your Honor, it's not equitable to have Ms. Munka have to help pay for the security. It is Robert's responsibility to pay for that security in the form of life insurance. So I think the argument of having them split the cost is disingenuous. There's also the argument that, well, we shouldn't require Robert to pay interest because Linda didn't have to pay spousal support until 2013. Robert had his property settlement from 2008. You know, the simple solution is not to do this all in nothing. The simple solution is, fine, have him pay interest from 2013 forward. Put them both in equal positions. Instead, the trial court said, no, we're just not going to do it at all because of that factor. It's overkill.
Well, what do you make of the inequities that Attorney Gibson raised? Was it not proper for the court to consider those? The fact she didn't pay spousal support when she was ordered to over the course of time, et cetera?
Well, as I mentioned before, Your Honor, neither did Robert. He didn't pay the property settlement. And we also have to look at the fact that in previous orders, it was an offset. It was basically, well, whatever she was going to pay, he doesn't have to pay. So, and this court remanded it and said to the trial court, you can't do that. You can't mix support and property settlement. So the court then fixed that from 2013 on. So I think that's what we have to look at, because that's when we finally have an order that stands legally. And so that's what we're looking at.
Sorry, but you used all your time at this point, so. Thank you both for your arguments today. Interesting case. The court will take it under advisement, issue a decision in due course, and the clerk of courts will mail you each copy of the decision on the day it's released. You can also keep an eye out on the Supreme Court of Ohio's website where the decisions are posted. Thank you both again.
Thank you.